Article 251. Death caused in a tumultuous affray. While several persons, not composing groups organized for the common purpose of assaulting and attacking each other reciprocally, quarrel and assault each other in a confused and tumultuous manner, and in the course of the affray someone is killed, and it cannot be ascertained who actually killed the deceased, but the person or persons who inflicted serious physical injuries can be identified, such person or persons shall be punished by prison mayor. If it cannot be determined who inflicted serious physical injuries on the deceased, the penalty of prison correctional, in its medium and maximum periods, shall be imposed upon all those who shall have used violence upon the person of the victim. Article 252. Physical injuries inflicted in a tumultuous affray. When in a tumultuous affray, as referred to in the preceding article, only serious physical injuries are inflicted upon the participants thereof, and the person responsible therefor cannot be identified, all those who appear to have used violence upon the person of the offended party shall suffer the penalty next lower in degree than that provided for the physical injuries so inflicted. When the physical injuries inflicted are of a less serious nature, and the person responsible therefor cannot be identified, all those who appear to have used any violence upon the person of the offended party shall be punished by arresto mayor from 5 to 15 days. Article 253. Giving assistance to suicide. Any person who shall assist another to commit suicide shall suffer the penalty of prison mayor if such person lends his assistance to another to the extent of doing the killing himself. He shall suffer the penalty of reclusion temporal. However, if the suicide is not consummated, the penalty of arresto mayor in its medium and maximum periods shall be imposed. Article 254. Discharge of firearms. Any person who shall shoot at another with any firearm shall suffer the penalty of prison correctional in its minimum and medium periods, unless the facts of the case are such that the act can be held to constitute frustrated or attempted parricide, murder, homicide, or any other crime for which a higher penalty is prescribed by any of the articles of this code. Section 2. Infanticide and abortion. Article 255. Infanticide. The penalty provided for parricide in Article 246 and for murder in Article 248 shall be imposed upon any person who shall kill any child less than 3 days of age. If the crime penalized in this article be committed by the mother of the child for the purpose of concealing her dishonor, she shall suffer the penalty of prison mayor in its medium and maximum periods, and if said crime be committed by the same purpose by the maternal grandparents or either of them, the penalty shall be reclusion temporal, as amended by R.A. number 7659, December 13, 1993. Article 256. Intentional abortion. Any person who shall intentionally cause an abortion shall suffer 1. The penalty of reclusion temporal, if he shall use any violence upon the person of the pregnant woman. 2. The penalty of prison mayor, if without using violence he shall act without the consent of the woman. 3. The penalty of prison correctional in its medium and maximum periods, if the woman shall have consented. Article 257. Unintentional abortion. The penalty of prison correctional in its minimum and medium periods shall be imposed upon any person who shall cause an abortion by violence but unintentionally. Article 258. Abortion practiced by the woman herself or by her parents. The penalty of prison correctional in its medium and maximum periods shall be imposed upon a woman who shall practice on abortion upon herself or shall consent that any other person should do so, Any woman who shall commit this offense to conceal her dishonor shall suffer the penalty of prison correctional in its minimum and medium periods. If this crime be committed by the parents of the pregnant woman or either of them, and they act with the consent of said woman, for the purpose of concealing her dishonor, the offenders shall suffer the penalty of prison correctional in its medium and maximum periods. Article 259. Abortion practiced by a physician or midwife and dispensing of abortives. The penalties provided in Article 256 shall be imposed in its maximum period respectively upon any physician or midwife who, taking advantage of their scientific knowledge or skill, shall cause an abortion or assist in causing the same. Any pharmacist who, without the proper prescription from a physician, shall dispense any abortive, shall suffer arresto mayor and a fine not exceeding 100,000 pesos. Section 3. Duel. Article 260. Responsibility of participants in a duel. The penalty of reclusion temporal shall be imposed upon any person who shall kill his adversary in a duel. If he shall inflict upon the latter physical injuries only, he shall suffer the penalty provided therefor, according to their nature. In any other case, the combatants shall suffer the penalty of arresto mayor, although no physical injuries have been inflicted. The seconds shall in all events be punished as accomplices. Article 261. Challenging to a duel. The penalty of prison correctional in its minimum period shall be imposed upon any person who shall challenge another or incite another to give or accept a challenge to a duel, or shall scoff at or decry another publicly for having refused to accept a challenge to fight a duel. Chapter 2. Physical Injuries. Article 262. Mutilation. The penalty of reclusion temporal to reclusion perpetua shall be imposed upon any person who shall intentionally mutilate another by depriving him either totally or partially of some essential organ of reproduction. Any other intentional mutilation shall be punished by prison mayor in its medium and maximum periods. Note: under Section 10 of RA 7610, the penalty for other intentional mutilation if the victim is under 12 years of age is reclusion perpetua. Article 263. Serious physical injuries. Any person who shall wound, beat, or assault another shall be guilty of the crime of serious physical injuries and shall suffer 1. The penalty of prison mayor, if in consequence of the physical injuries inflicted the injured person shall become insane, imbecile, impotent, or blind. 2. The penalty of prison correctional in its medium and maximum periods if in consequence of the physical injuries inflicted the person injured shall have lost the use of speech or the power to hear or to smell, or shall have lost an eye, a hand, a foot, an arm, or a leg, or shall have lost the use of any such member, or shall have become incapacitated for the work in which he was therefore habitually engaged. 3. The penalty of prison correctional in its minimum and medium periods, if in consequence of the physical injuries inflicted, the person injured shall have become deformed, or shall have lost any part of his body, or shall have lost the use thereof, or shall have been ill or incapacitated for the performance of the work in which he was habitually engaged for a period of more than 90 days. 4. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period, if the physical injuries inflicted shall have caused the illness or incapacity for labor of the injured person for more than 30 days. If the offense shall have been committed against any of the person enumerated in Article 246, or with attendance of any of the circumstances mentioned in Article 248, the case covered by subdivision number 1 of this article shall be punished by reclusion temporal in its medium and maximum periods. the case covered by subdivision number 2 by prison correctional in its maximum period to prison mayor in its minimum period. The case covered by subdivision number 3 by prison correctional in its medium and maximum periods, and the case covered by subdivision number 4 by prison correctional in its minimum periods and medium periods. The provisions of the preceding paragraph shall not be applicable to a parent who shall inflict injuries upon his child by excessive chastisement. Note: under Section 10 of RA 7610, the penalty for serious physical injuries, if the victim is under 12 years of age, is reclusion perpetua. Article 264, administering injurious substances or beverages. The penalties established by the next preceding article shall be applicable in the respective case to any person who, without intent to kill, shall inflict upon another any serious physical injury, by knowingly administering to him any injurious substances or beverages, or by taking advantage of his weakness of mind or credulity. Article 265. Less serious physical injuries. Any person who shall inflict upon another physical injuries not described in the preceding articles, but which shall incapacitate the offended party for labor for 10 days or more, or shall require medical assistance for the same period, shall be guilty of less serious physical injuries and shall suffer the penalty of arresto mayor, whenever less serious physical injuries shall have been inflicted with the manifest intent to insult or offend the injured person, or under circumstances adding ignominy to the offense. In addition to the penalty of arresto mayor, a fine not exceeding 50,000 pesos shall be imposed. And less serious physical injuries inflicted upon the offender's parents, ascendants, guardians, curators, teachers, or persons of rank, or persons in authority shall be punished by prison correctional in its minimum and medium periods, provided that in the case of persons in authority, the deed does not constitute a crime of assault upon such persons, as amended by RA 10951, August 29, 2017. Article 266. Slight physical injuries and maltreatment. The crime of slight physical injuries shall be punished by 1. Arresto minor when the offended has inflicted physical injuries which shall incapacitate the offended party for labor from 1 to 9 days, or shall require medical attendance during the same period. Number 2. By arresto minor, or a fine not exceeding 40,000 pesos, and censure when the offender has caused physical injuries which do not prevent the offended party from engaging in his habitual work, nor require medical assistance. Number 3. By arresto minor in its minimum period, or a fine not exceeding 5,000 pesos when the offender shall ill-treat another by deed without causing any injury, as amended by RA 10951, August 29, 2017. Chapter 3. Rape. Article 266-A. Rape. When and how committed. Rape is committed by 1. By a man who shall have carnal knowledge of a woman under any of the following circumstances: A. Through force, threat, or intimidation. B. When the offended party is deprived of reason or is otherwise unconscious. C. By means of fraudulent machination or a grave abuse of authority. D. When the offended party is under 12 years of age or is demented, even though none of the circumstances mentioned above be present. Number 2. By any person who, under any of the circumstances mentioned in paragraph 1 hereof, shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice, or any instrument or object into the genital or anal orifice of another person. RA 8353, October 22, 1997.
Article 266-B, Penalties. Rape under paragraph 1 of the next preceding article shall be punished by reclusion perpetua. Whenever the rape is committed with the use of a deadly weapon or by two or more persons, the penalty shall be reclusion perpetua to death. When by reason or on the occasion of the rape, the victim has become insane, the penalty shall be reclusion perpetua to death. When the rape is attempted and a homicide is committed by reason or on the occasion thereof, the penalty shall be reclusion perpetua to death. When by reason or on the occasion of the rape, homicide is committed, the penalty shall be death. The death penalty shall also be imposed if the crime of rape is committed with any of the following aggravating or qualifying circumstances. 1. When the victim is under 18 years of age and the offender is a parent, ascendant, step-parent, guardian, relative by consanguinity or affinity within the third civil degree, or the common law spouse of the parent of the victim. 2. When the victim is under the custody of the police or military authorities or any law enforcement or penal institution. 3. When the rape is committed in full view of the spouse, parent, any of the children, or other relatives within the third civil degree of consanguinity. 4. When the victim is a religious engaged in legitimate religious vocation or calling, and is personally known to be such by the offender before or at the time of the commission of the crime. 5. When the victim is a child below 7 years old. 6. When the offender knows that he is afflicted with human immunodeficiency virus or HIV or acquired immune deficiency syndrome AIDS or any other sexually transmissible disease and the virus or disease is transmitted to the victim. 7. When committed by any member of the armed forces of the Philippines or paramilitary units thereof or the Philippine National Police or any law enforcement agency or penal institution, when the offender took advantage of his position to facilitate the commission of the crime. 8. When by reason or on the occasion of the rape, the victim has suffered permanent physical mutilation or disability. 9. When the offender knew of the pregnancy of the offended party at the time of the commission of the crime. 10. When the offender knew of the mental disability, emotional disorder, or and physical handicap of the offended party at the time of the commission of the crime. Rape under paragraph 2 of the next preceding article shall be punished by prison mayor. Whenever the rape is committed with the use of a deadly weapon or by two or more persons, the penalty shall be prison mayor to reclusion temporal. When the rape is attempted and a homicide is committed by reason or on the occasion thereof, the penalty shall be reclusion temporal to reclusion perpetua. When by reason or on the occasion of rape, homicide is committed, the penalty shall be reclusion perpetua. Reclusion temporal shall also be imposed if the rape is committed by any of the 10 aggravating or qualifying circumstances mentioned in this article, R.A. number 8353, September 30, 1997. Article 266-C. Effect of pardon. The subsequent valid marriage between the offender and the offended party shall extinguish the criminal action or the penalty imposed. In case it is the legal husband who is the offender, the subsequent forgiveness by the wife as the offended party shall extinguish the criminal action or the penalty, provided that the crime shall not be extinguished or the penalty shall not be abated if the marriage be void ab initio. R.A. 8353, September 30, 1997. Article 266-D. Presumptions. Any physical overt act manifesting resistance against the act of rape in any degree from the offended party, or where the offended party is so situated as to render her or him incapable of giving valid consent, may be accepted as evidence in the prosecution of the acts punished under Article 266-A. Title 9. Crimes against personal liberty and security. Chapter 1. Crimes against liberty. Section 1. Illegal detention. Article 267. Kidnapping and serious illegal detention. Asterisk. And a private individual who shall kidnap or detain another, or in any other manner deprive him of his liberty, shall suffer the penalty of reclusion perpetua to death. 2 asterisk. Number 1. If the kidnapping or detention shall have lasted more than 3 days. Number 2. If it shall have been committed simulating public authority. Number 3. If any serious physical injuries shall have been inflicted upon the person kidnapped or detained, or if threats to kill him shall have been made. Number 4. If the person kidnapped or detained shall be a minor, except when the accused is any of the parents, female, or a public officer. The penalty shall be that where the kidnapping or detention was committed for the purpose of extorting ransom from the victim or any other person, even if none of the circumstances above mentioned were present in the commission of the offense. When the victim is killed or dies as a consequence of the detention, or is raped, or is subjected to torture or dehumanizing acts, the maximum penalty shall be imposed, as amended by R.A. 7659, December 13, 1993. Asterisk. Kidnapping is a predicate crime of terrorism under R.A. number 9372. Article 268. Slight illegal detention. The penalty of reclusion temporal shall be imposed upon any private individual who shall commit the crime described in the next preceding article without the attendance of any of the circumstances enumerated therein. The same penalty shall be incurred by anyone who shall furnish the place for the perpetration of the crime, if the offender shall voluntarily release the person so kidnapped or detained within 3 days from the commencement of the detention without having attained the purpose intended, and before the institution of criminal proceedings against him. The penalty shall be prison mayor in its minimum and medium periods, and a fine not exceeding 100,000 pesos. Article 269. Unlawful arrest. The penalty of arresto mayor and a fine not exceeding 100,000 pesos shall be imposed upon any person who, in any case other than those authorized by law, or without reasonable ground therefor, shall arrest or detain another for the purpose of delivering him to the proper authorities, as amended by R.A. 10951. Section 2. Kidnapping of minors. Article 270. Kidnapping and failure to return a minor. The penalty of reclusion perpetua shall be imposed upon any person who, being entrusted with the custody of a minor person, shall deliberately fail to restore the latter to his parents or guardians, as amended by R.A. number 18, September 25, 1946. Article 271. Inducing a minor to abandon his home. The penalty of prison correctional and a fine not exceeding 100,000 pesos shall be imposed upon any one who shall induce a minor to abandon the home of his parents or guardians, or the persons entrusted with his custody, if the person committing any of the crimes covered by the 2 preceding articles shall be the father or the mother of the minor. The penalty shall be arresto mayor or a fine not exceeding 40,000 pesos, or both. Section 3. Slavery and Servitude. Article 272. Slavery asterisk. The penalty of prison mayor and a fine not exceeding 10,000 pesos shall be imposed upon anyone who shall purchase, sell, kidnap, or detain a human being for the purpose of enslaving him, if the crime be committed for the purpose of assigning the offended party to some immoral traffic. The penalty shall be imposed in its maximum period. Article 273. Exploitation of child labor asterisk. The penalty of prison correctional in its minimum and medium periods, and a fine not exceeding 500 pesos, shall be imposed upon anyone who, under the pretext of reimbursing him of a debt incurred by an ascendant, guardian, or person entrusted with the custody of a minor, shall against the latter's will retain him in his service. Article 274. services rendered under compulsion in payment of debts, the penalty of arresto mayor in its maximum period to prison correctional and its minimum period shall be imposed upon any person who, in order to require or enforce the payment of a debt, shall compel the debtor to work for him, against his will, as household servant or farm laborer. Chapter 2. Crimes Against Security. Section 1. Abandonment of helpless persons and exploitation of minors. Asterisk. Article 275. Abandonment of person in danger and abandonment of one's own victim. The penalty of arresto mayor shall be imposed upon 1. Anyone who shall fail to render assistance to any person whom he shall find in an inhabited place, wounded, or in danger of dying, when he can render such assistance without detriment to himself, unless such omission shall constitute a more serious offense. 2. Anyone who shall fail to help or render assistance to another whom he has accidentally wounded or injured. 3. Anyone who, having found an abandoned child under 7 years of age, shall fail or deliver said child to the authorities or to his family, or shall fail to take him to a safe place. Article 276. Abandoning a minor. The penalty of arresto mayor and a fine not exceeding 100,000 pesos shall be imposed upon anyone who shall abandon a child under 7 years of age, the custody of which is incumbent upon him. When the death of a minor shall result from such abandonment, the culprit shall be punished by prison correctional in its medium and maximum periods. But if the life of the minor shall have been in danger of, the penalty shall be prison correctional in its minimum and medium periods. The provisions contained in the 2 preceding paragraphs shall not prevent the imposition of the penalty provided for the act committed, when the same shall constitute a more serious offense, as amended by RA 10951. Article 277. Abandonment of minor by person entrusted with his custody. Indifference of parents. The penalty of arresto mayor and a fine not exceeding 100,000 pesos shall be imposed upon anyone who, having charge of the rearing or education of a minor, shall deliver said minor to a public institution or other persons without the consent of the one who entrusted such child to his care, or, in the absence of the latter, without the consent of the proper authorities. The same penalty shall be imposed upon the parents who shall neglect their children by not giving them the education which their station in life requires and financial conditions permits. Article 278. Exploitation of minors. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 100,000 pesos shall be imposed upon 1. Any person who shall cause any boy or girl under 16 years of age to perform any dangerous feat of balancing, physical strength, or contortion. 2. Any person who, being an acrobat, gymnast, rope walker, driver, wild animal tamer, or circus manager, or engage in a similar calling, shall employ in exhibition of these kinds children under 16 years of age who are not his children or descendants. 3. Any person engaged in any of the callings enumerated in the next preceding paragraph who shall employ any descendant of his under 12 years of age in such dangerous exhibitions. 4. Any ascendant, guardian, teacher, or a person entrusted in any capacity with the care of a child under 16 years of age, who shall deliver such child gratuitously to any person following any of their callings enumerated in paragraph 2 hereof, or to any habitual, vagrant, or beggar. If the delivery shall have been made in consideration of any price, compensation, or promise, the penalty shall in every case be imposed in its maximum period. In either case, the guardian or curator convicted shall also be removed from office as guardian or curator, and in the case of the parents of the child, they may be deprived temporarily or perpetually, in the discretion of the court, of their parental authority, as amended by RA 10951, August 29, 2017. Number 5. Any person who shall induce any child under 16 years of age to abandon the home of its ascendants, guardians, curators, or teacher, to follow any person engaged in any of the callings mentioned in paragraph 2 hereof, or to accompany any habitual vagrant or beggar, as amended by RA 10951. Article 279. Additional penalties for other offenses. The imposition of the penalties in the preceding articles shall not prevent the imposition upon the same person of the penalty provided for any other felonies defined and punished by this code. Section 2. Trespass to dwelling. Article 280. Qualified trespass to dwelling. Any private person who shall enter the dwelling of another against the latter's will shall be punished by arresto mayor and a fine not exceeding 200,000 pesos. If the offense be committed by means of violence or intimidation, the penalty shall be prison correctional in its medium and maximum periods, and a fine not exceeding 200,000 pesos. The provisions of this article shall not be applicable to any person who shall enter another's dwelling for the purpose of preventing some serious harm to himself, the occupants of the dwelling, or a third person, nor shall it be applicable to any person who shall enter a dwelling for the purpose of rendering some service to humanity or justice, or to anyone who shall enter cafes, taverns, inns, and other public houses while the same are open. Article 281. Other forms of trespass. The penalty of arresto menor, or a fine not exceeding 40,000 pesos, or both, shall be imposed upon any person who shall enter the closed premises or the fenced estate of another, while either or both of them are inhabited, if the prohibition to enter be manifest, and the trespasser has not secured the permission of the owner or the caretaker thereof. Section 3. Threats and coercion. Article 282. Grave threats. And a person who shall threaten another with the infliction upon the person, owner, or property of the latter, or of his family, or any wrong amounting to a crime, shall suffer, number 1, the penalty next lower in degree than that prescribed by law for the crime he threatened to commit. If the offender shall have made the threat demanding money or imposing any other condition, even though not unlawful, and said offender shall have attained his purpose. If the offender shall not have attained his purpose, the penalty lower by 2 degrees shall be imposed. If the threat be made in writing or through a middleman, the penalty shall be imposed in its maximum period. Number 2. The penalty of arresto mayor and a fine not exceeding 100,000 pesos if the threat shall not have been made subject to a condition, as amended by RA 10951. Article 283. Light threats. A threat to commit a wrong not constituting a crime made in the manner expressed in subdivision 1 of the next preceding article shall be punished by arresto mayor. Article 284. Bond for good behavior. In all cases falling within the 2 next preceding articles, the person making the threats may also be required to give bail, not to molest the person threatened, or if he shall fail to give such bail, he shall be sentenced to destierro. Article 285. Other light threats. The penalty of arresto menor in its minimum period, or a fine not exceeding 40,000 pesos, shall be imposed upon 1. Any person who, without being included in the provisions of the next preceding article, shall threaten another with a weapon, or draw such weapon in a quarrel, unless it be lawful self-defense. Number 2. Any person who, in the heat of anger, shall orally threaten another with some harm not constituting a crime, and who by subsequent acts shows that he did not persist in the idea involved in his threat, provided that the circumstances of the offense shall not bring it within the provisions of Article 282 of this code. Number 3. Any person who shall orally threaten to do another any harm not constituting a felony, as amended by RA 10951. Article 286. Grave coercions. The penalty of prison correctional and a fine not exceeding 100,000 pesos shall be imposed upon any person who without any authority of law shall, by means of violence, threats, or intimidation, prevent another by doing something not prohibited by law, or compel him to do something against his will, whether it be right or wrong, if the coercion be committed in violation of the exercise of the right of suffrage, or for the purpose of compelling another to perform any religious act, or to prevent him from exercising such right, or from so doing such act, the penalty next higher in degree shall be imposed. Article 287. Light coercions. Any person who, by means of violence, shall seize anything belonging to his debtor for the purpose of applying the same to the payment of the debt, shall suffer the penalty of arresto mayor in its minimum period, and a fine equivalent to the value of the thing, but in no case less than 15,000 pesos. Any other coercions or unjust vexations shall be punished by arresto menor, or a fine ranging from 1,000 pesos to not more than 40,000 pesos, or both, as amended by RA 10951. Article 288. Other similar coercions. Compulsory purchase of merchandise and payment of wages by means of tokens. The penalty of arresto mayor, or a fine ranging from 40,000 pesos to 100,000 pesos, or both, shall be imposed upon any person, agent, or officer, or any association or corporation, who shall force or compel directly or indirectly, or shall knowingly permit any laborer or employee employed by him or by such firm or corporation to be forced or compelled to purchase merchandise or commodities of any kind. The same penalties shall be imposed upon any person who shall pay the wages due a laborer or employee employed by him by means of tokens or objects other than the legal tender currency of the Philippines, unless expressly requested by the laborer or employee, as amended by RA 10951. Chapter 3. Discovery and Revelation of Secrets. Article 289. Formation, maintenance, and prohibition of combination of capital or labor through violence or threats. The penalty of arresto mayor and a fine not exceeding 60,000 pesos shall be imposed upon any person who, for the purpose of organizing, maintaining, or preventing coalitions of capital or labor, strike of laborers, or lockout of employers, shall employ violence or threats in such a degree as to compel or force the laborers or employees in the free and legal exercise of their industry or work, if the act shall not constitute a more serious offense, in accordance with the provisions of this code, as amended by RA 10951. Article 290. Discovering secrets through seizure of correspondence. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 100,000 pesos shall be imposed upon any private individual who, in order to discover the secrets of another, shall seize his papers or letters and reveal the contents thereof. If the offender shall not reveal such secrets, the penalty shall be arresto mayor and a fine not exceeding 100,000 pesos. This provision shall not be applicable to parents, guardians, or persons entrusted with the custody of minors with respect to the papers or letters of the children or minors placed under their care or custody, nor to spouses with respect to the papers or letters of either of them, as amended by RA 10951. Article 291. Revealing secrets with abuse of office. The penalty of arresto mayor and a fine not exceeding 100,000 pesos shall be imposed upon any manager, employee, or servant who in such capacity shall learn the secrets of his principal or master, and shall reveal such secrets, as amended by RA 10951. Article 292, Revelation of Industrial Secrets. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 100,000 pesos shall be imposed upon the person in charge, employee, or workman of any manufactory or industrial establishment who, to the prejudice of the owner thereof, shall reveal the secrets of the industry of the latter, as amended by R.A. 10951. Title 10, Crimes Against Property, Chapter 1, Robbery in General. Article 293. Who are guilty of robbery, asterisk. Any person who, with intent to gain, shall take any personal property belonging to another by means of violence against or intimidation of any person, or using force upon anything, shall be guilty of robbery. Section 1. Robbery with violence against or intimidation of persons. Article 294. Robbery with violence against or intimidation of persons. Penalties. Any person guilty of robbery with the use of violence against or intimidation of any person shall suffer 1. The penalty of reclusion perpetua to death, when by reason or on occasion of the robbery the crime of homicide shall have been committed, or when the robbery shall have been accompanied by rape or intentional mutilation or arson. 2. The penalty of reclusion temporal in its medium period to reclusion perpetua, when or if by reason or on occasion of such robbery any of the physical injuries penalized in subdivision 1 of Article 263 shall have been inflicted. 3. The penalty of reclusion temporal, when by reason or on occasion of the robbery any of the physical injuries penalized in subdivision 2 of the article mentioned in the next preceding paragraph shall have been inflicted. 4. The penalty of prison mayor in its maximum period to reclusion temporal in its medium period, if the violence or intimidation employed in the commission of the robbery shall have been carried to a degree clearly unnecessary for the commission of the crime, or when in the course of its execution the offender shall have inflicted upon any person not responsible for its commission any of the physical injuries covered by subdivisions 3 and 4 of said Article 263. 5. The penalty of prison correctional in its maximum period to prison mayor in its medium period in other cases. Article 295. Robbery with physical injuries committed in an inhabited place and by a band or with the use of firearm on a street, road, or alley. If the offenses mentioned in subdivisions 3, 4, and 5 of the next preceding article shall have been committed in an uninhabited place, or by a band, or by attacking a moving train, streetcar, motor vehicle, or airship, or by entering the passengers' compartments in a train, or in any manner taking the passengers thereof by surprise in the respective conveyances, or on a street, road, highway, or alley, and the intimidation is made with the use of firearm, and the offender shall be punished by the maximum period of the proper penalties. In the same cases, the penalty next higher in degree shall be imposed upon the leader of the band. Article 296. Definition of a band and penalty incurred by the members thereof. When more than 3 armed malefactors take part in the commission of robbery, it shall be deemed to have been committed by a band. When any of the arms used in the commission of the offense be an unlicensed firearm, the penalty be imposed upon all the malefactors shall be the maximum of the corresponding penalty provided by law, without prejudice to the criminal liability for illegal possession of such unlicensed firearm. Any member of a band who is present at the commission of a robbery by the band shall be punished as principal of any of the assaults committed by the band, unless it be shown that he attempted to prevent the same. Article 297. Attempted and frustrated robbery committed under certain circumstances. When by reason or on occasion of an attempted or frustrated robbery, a homicide is committed, the person guilty of such offenses shall be punished by reclusion temporal in its maximum period to reclusion perpetua, unless the homicide committed shall deserve a higher penalty under the provisions of this code. Article 298. Execution of deeds by means of violence or intimidation. Any person who, with intent to defraud another by means of violence or intimidation, shall compel him to sign, execute, or deliver any public instrument or document shall be held guilty of robbery and punished by the penalties respectively prescribed in this chapter. Section 2. Robbery by use of force upon things. Article 299. Robbery in an inhabited house or public building or edifice devoted to worship. Any armed person who shall commit robbery in an inhabited house or public building or edifice devoted to religious worship shall be punished by reclusion temporal, if the value of the property taken shall exceed 50,000 pesos, and if a. the malefactors shall enter the house or building in which the robbery was committed by any of the following means: 1. Through an opening not intended for entrance or egress. 2. By breaking any wall, roof, or floor, or breaking any door or window. 3. By using false keys, picklocks, or similar tools. 4. By using any fictitious name or pretending the exercise of public authority, or if b. the robbery be committed under any of the following circumstances: 1. By the breaking of doors, wardrobes, chests, or any other kind of locked or sealed furniture or receptacle. 2. By taking such furniture or objects away to be broken or forced open outside the place of the robbery. When the offenders do not carry arms, and the value of the property taken exceeds 50,000 pesos, the penalty next lower in degree shall be imposed. The same rule shall be applied when the offenders are armed, but the value of the property taken does not exceed 50,000 pesos. When said offenders do not carry arms, and the value of the property taken does not exceed 50,000 pesos, they shall suffer the penalty prescribed in the two next preceding paragraphs in its minimum period. If the robbery be committed in one of the dependencies of an inhabited house, public building, or building dedicated to religious worship, the penalties next lower in degree than those prescribed in this article shall be imposed. Article 300. Robbery in an inhabited place and by a band. The robbery mentioned in the next preceding article, if committed in an inhabited place and by a band, shall be punished by the maximum period of the penalty provided thereof. Article 301. What is an inhabited house, public building, or building dedicated to religious worship, and their dependencies? Inhabited house means any shelter, ship, or vessel constituting the dwelling of one or more persons, even though the inhabitants thereof shall temporarily be absent therefrom when the robbery is committed. All interior courts, corrals, warehouses, granaries, barns, coach houses, stables, or other departments or enclosed places contiguous to the building or edifice having an interior entrance connected therewith, and which form part of the whole, shall be deemed dependencies of an inhabited house, public building, or building dedicated to religious worship. Orchards and other lands used for cultivation or production are not included in the terms of the next preceding paragraph, even if close, contiguous to the building and having direct connection therewith. The term public building includes every building owned by the government or belonging to a private person, but used or rented by the government, although temporarily unoccupied by the same. Article 302. Robbery in an inhabited place or in a private building. Any robbery committed in an inhabited place or in a building other than those mentioned in the first paragraph of Article 299, if the value of the property taken exceeds 50,000 pesos shall be punished by prison correctional in its medium and maximum periods, provided that any of the following circumstances is present. Number 1. If the entrance has been effected through any opening not intended for entrance or egress. Number 2. If any wall, roof, floor, or outside door or window has been broken. Number 3. If the entrance has been effected through the use of false keys, picklocks, or other similar tools. Number 4. If any door, wardrobe, chest, or any sealed or closed furniture or receptacle has been broken. Number 5. If any closed or sealed receptacle as mentioned in the preceding paragraph has been removed, even if the same be broken open elsewhere. When the value of the property taken does not exceed 50,000 pesos, the penalty next lower in degree shall be imposed. In the cases specified in Articles 294, 295, 297, 299, 300, and 302 of this Code, when the property taken is mail, matter, or large cattle, the offender shall suffer the penalties next higher in degree than those provided in said articles. Article 303. Robbery of cereals, fruits, or firewood in an inhabited place or private building. In the cases enumerated in Articles 299 and 302, when the robbery consists in the taking of cereals, fruits, or firewood, the culprit shall suffer the penalty next lower in degree than that prescribed in said articles. Article 304. Possession of picklocks or similar tools. Any person who shall, without lawful cause, have in his possession picklocks or similar tools specially adapted to the commission of the crime of robbery shall be punished by arresto mayor in its maximum period to prison correctional in its minimum period. The same penalty shall be imposed upon any person who shall make such tools, or the offender be a locksmith, he shall suffer the penalty of prison correctional in its medium and maximum periods. Article 305. False keys. The term false keys shall be deemed to include 1. The tools mentioned in the next preceding article. Number 2. Genuine keys stolen from the owner. Number 3. Any keys other than those intended by the owner for use in the lock forcibly opened by the offender. Chapter 2. Brigandage. Article 306. Who are brigands? Penalty. When more than 3 armed persons form a band of robbers for the purpose of committing robbery in the highway, or kidnapping persons for the purpose of extortion, or to obtain ransom, or for any other purpose to be attained by means of force and violence, they shall be deemed highway robbers or brigands. Persons found guilty of this offense shall be punished by prison mayor in its medium period to reclusion temporal in its minimum period, if the act or acts committed by them are not punishable by higher penalties, in which case they shall suffer such high penalties. If any of the arms carried by any of said persons be an unlicensed firearm, it shall be presumed that said persons are highway robbers or brigands, and in case of conviction, the penalty shall be imposed in the maximum period, as amended by R.A. No. 12, September 5, 1946. CPD 532 on highway robberies or brigandage. Article 307. Aiding and abetting a band of brigands. Any person knowingly and in any manner aiding, abetting, or protecting a band of brigands, as described in the next preceding article, or giving them information of the movements of the police or other peace officer of the government, or of the forces of the United States Army, when the latter are acting in aid of the government, or acquiring or receiving the property taken by such brigands, shall be punished by prison correctional in its medium period to prison mayor in its minimum period. It shall be presumed that the person performing any of the acts provided in this article has performed them knowingly, unless the contrary is proven. Chapter 3. Taft. Article 308. Who are liable for theft. Theft is committed by any person who, with intent to gain, but without violence against or intimidation of persons, nor force upon things, shall take personal property of another without the latter's consent. Theft is likewise committed by one and a person who, having found lost property, shall fail to deliver the same to the local authorities or to its owner. Number 2. And a person who, after having maliciously damaged the property of another, shall remove or make use of the fruits of or objects of the damage caused by him. And 3. And a person who shall enter an enclosed estate or a field where trespass is forbidden, or which belongs to another and without the consent of its owner, shall hunt or fish upon the same, or shall gather fruits, cereals, or other forest or farm products. Article 309. Penalties. And a person guilty of theft shall be punished by 1. The penalty of prison major in its minimum and medium periods, if the value of the things stolen is more than 1,200,000 pesos, but does not exceed 2,200,000 pesos. But if the value of the things stolen exceeds the latter amount, the penalty shall be the maximum period of the one prescribed in this paragraph, and 1 year for each additional 1,000,000 pesos. But the total of the penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed, and for the purpose of the other provisions of this code, the penalty shall be termed prison major or reclusion temporal, as the case may be. Number 2. The penalty of prison correctional in its medium and maximum periods, if the value of the things stolen is more than 600,000 pesos, but does not exceed 1,200,000 pesos. The penalty of prison correctional in its minimum and medium periods, if the value of the property stolen is more than 20,000 pesos, but does not exceed 600,000 pesos. Number 4. Arresto mayor in its medium period to prison correctional in its minimum period, if the value of the property stolen is over 5,000 pesos, but does not exceed 20,000 pesos. Number 5. Arresto mayor to its full extent, if such value is over 500 pesos, but does not exceed 5,000 pesos. Number 7. Arresto mayor in its minimum and medium periods, if such value does not exceed 500 pesos. Number 7. Arresto menor, or a fine not exceeding 20,000 pesos, if the theft is committed under the circumstances enumerated in paragraph 3 of the next preceding article, and the value of the thing stolen does not exceed 500 pesos. If such value exceeds such amount, the provision of any of the 5 preceding subdivisions shall be made applicable. Number 8. Arresto menor in its minimum period, or a fine not exceeding 5,000 pesos, when the value of the thing stolen is not over 500 pesos, and the offender shall have acted under the impulse of hunger, poverty, or the difficulty of earning a livelihood for the support of himself or his family, as amended by R.A. 10951, August 29, 2017. Article 310. Qualified theft. The crime of theft shall be punished by the penalties next higher, by 2 degrees than those respectively specified in the next preceding articles, if committed by a domestic servant, or with grave abuse of confidence, or if the property stolen is motor vehicle, mail matter, or large cattle, or consists of coconuts taken from the premises of the plantation, or fish taken from a fish pond or fishery, or if property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbances. Article 311. Theft of the property of the National Library and National Museum. If the property stolen be any property of the National Library or the National Museum, the penalty shall be arresto mayor and a fine ranging from 40,000 pesos to 100,000 pesos, or both, unless a higher penalty should be provided under other provisions of this code, in which case the offender shall be punished by such higher penalty, as amended by R.A. 10951, August 29, 2017. Chapter 4. Usurpation. 312 Article. Occupation of real property, of usurpation of real rights in property. Any person who, by means of violence against or intimidation of persons, shall take possession of any real property, or shall usurp any real rights in property belonging to another, in addition to the penalty incurred for the acts of violence executed by him, shall be punished by a fine from 50 to 100 per centum of the gain which he shall have obtained, but not less than 15,000 pesos. If the value of the gain cannot be ascertained, a fine from 40,000 pesos to 100,000 pesos shall be imposed, as amended by RA 10951. Article 313. Altering boundaries or landmarks. And a person who shall alter the boundary marks or monuments of towns, provinces, or states, or any other marks intended to designate the boundaries of the same, shall be punished by arresto menor, or a fine not exceeding 20,000 pesos, or both, as amended by RA 10951. Chapter 5. Culpable insolvency. Article 314. Fraudulent insolvency. Any person who shall abscond with his property to the prejudice of his creditors shall suffer the penalty of prison mayor, if he be a merchant, and the penalty of prison correctional in its maximum period to prison mayor in its medium period, if he be not a merchant.